on this episode of Charged and Disbarred.
Kevin Steele's motivation is to save face of the fund. But to take that and go to a level of committing financial fraud doesn't make any sense at all.
Bradley Slogrove approached the court inappropriately. As a lawyer, you shouldn't be making any threats at all. He argued that he was being a good advocate, arguing for his client's case.
Judges and attorneys are like kings and knights in their own realm. It is unthinkable that in a moment of madness it can all be thrown away. Charged and Disbarred explores the true life stories of attorneys who have fallen from grace. Hear firsthand accounts from the victims, detectives, and prosecutors who brought these disgraced attorneys to justice. This is Charged and Disbarred. As St. Paul famously said almost 2,000 years ago, do not be misled. Bad company corrupts good character. No matter how many times parents, pastors, and prophets utter these words, there are unfortunate souls who refuse to heed the warning. Kevin Steele was one of them.
I'm Michael McCabe. I'm an attorney in Baltimore, Maryland. I've been practicing law since 1992. I am a 1985 graduate of the University of Maryland, where I graduated with a degree in mechanical engineering. I worked for 4 years before attending law school as an engineer for NASA at the Goddard Space Flight Center. I attended law school at night while I was working at NASA and received my law degree in 1992 from the University of Baltimore School of Law. My practice involves representing lawyers and law firms who are involved in ethical complaints and related matters. Kevin Steele was a very well-respected partner at a very well-respected law firm in London. The law firm was called Reyes. This is the firm that represented Princess Diana in her divorce proceedings from Prince Charles.
Growing up, Kevin Steele was a model student who displayed a clear vision for his life early on. He had a classic English middle-class upbringing, complete with the privilege of attending a top-quality school and therefore benefiting from a superior education. Not surprisingly, Steele headed straight to law school, where he continued his studies until he passed the bar exam. Kevin Steele was admitted to the Bar Council of England and Wales on January 15, 1990. Over the next 20 years, Kevin Steele enjoyed a very successful legal career, culminating in his ascension to the position of equity partner at Michon de Reyes, a highly prestigious law firm that has represented clients from Microsoft to Princess Diana. As a further testament to his stellar reputation and professional achievement, Kevin Steele was asked to serve as the director of the board of Queen's Park Rangers Football Club, one of the oldest soccer clubs in England. Kevin Steele had reached the epitome of success when in July 2007 he met Michael Shepard, a wealthy businessman of Wellington Road, Lancaster. In Mr. Steele's own words, he thought Michael Shepard was a very nice man. According to Steele, Shepard confided that he was a man of considerable means. He'd made his fortune in the nightclub business in the Far East and from trading in precious gems, mainly diamonds. In fact, on occasion, Mr. Shepard would accept diamonds as payments for deals instead of cash. Steele and Shepard's friendship quickly turned into a business and professional relationship. Michael Shepard, known as the founding owner of the online insurance entity Claims Direct, had a new venture in mind. He wanted to build a luxury hotel resort in Turkey. Kevin Steele eagerly signed on as legal counsel, which meant helping Mr. Shepard secure a $25 million loan for the development of the new Turkish resort. Kevin Steele saw this not only as a business opportunity, but as the perfect solution to a colossal problem he'd been hiding from his partner.
Kevin Steele lost his way first by representing a Russian client who provided some very bad legal advice for him. The Russian client was very unhappy with Kevin and wanted $2.5 million in fees back that he paid Kevin's law firm.
Due to the negligent counsel given by Steele, the firm was potentially liable for millions of dollars to a Russian client. Instead of alerting the misconduct partners to his malpractice, Kevin Steele opted to keep quiet and raise the money himself to repay the client. It is standard practice for a bank to require a borrower seeking a loan to provide sufficient collateral in the event the borrower defaults. However, Shepherd could not provide such collateral. Desperate for this transaction, Steele assisted in the creation of fake documents submitted to EFG Private Bank, a Swiss-based global company, to support the bogus claim that Shepherd had access to a £76 million fortune.
Kevin and a fraudster, who was also a client of Kevin's, devised a scheme to raise money from a bank. The purported purpose of borrowing the money from the bank was that the client was needing $25 million to buy an investment property in Turkey. In order for the bank to lend that kind of money to this individual, they needed to see evidence that the individual was himself worth a lot of money. Kevin Steele and his client devised and created false financial statements and false bank records that falsely represented that the client was worth hundreds of millions of dollars.
This fraud was enabled in part by the implicit trust institutions such as EFG Private Bank had in both Kevin Steele and his world-renowned law firm. The authenticity of the documents he submitted on behalf of his firm and his clients were never questioned. Kevin Steele took the trust he earned during decades of practice and used it as a weapon of fraud.
He was able to convince the bank to loan his client $25 million. So, Kevin's client got the $25 million. The client took half of the money and actually used it to buy an investment property in Turkey. The other $12.5 million of the money that was borrowed was then deposited in the law firm's trust account under Kevin's name on behalf of this client with the firm.
Kevin Steele's plan seemed to be working. Half of the money was used to buy a hotel site in Turkey, and the balance of the funds were placed into Shepherd's account at the law firm. Steele then used £1.8 million to indemnify the aggrieved Russian client.
With the $12.5 million that was still left at the firm, Kevin then took $2.5 million from that for himself, which he then converted and turned over to the Russian clients to try to make them happy and say, look, I've made you whole again. Here's $2.5 million for you. So now you have nothing to complain about.
In most elaborate fraud cases, it takes several people to perpetrate the scheme. It was no different with Kevin Steele and Michael Shepherd. Mark Pattinson had been a longtime assistant of Mr. Shepherd and ran part of the fraud from his house, forging documents that looked like authentic instruments from Bank Julius Baer, a global Swiss private bank. Unfortunately for these fraudsters, they left clear signs of wrongdoing. It was only a matter of time before they got caught.
Unfortunately, with all of this paper trail, his firm found out about it. And in 2008, Kevin was fired from the law firm.
Termination was only the beginning of the nightmare caused by Kevin Steele's misconduct. He was charged with conspiracy to commit fraud and fraud by abusing his position at misconduct. He always maintained his innocence and contested the charges, compelling prosecutors to take him to trial.
Kevin faced significant criminal fraud charges, which he was ultimately found guilty of, and in 2012 was sentenced to 5.5 years in prison.
Why would anybody with such a successful career risk it all just to avoid the embarrassment and expense of a legal malpractice claim? What could have been Kevin Steele's motivation?
Kevin Steele's motivation was to save face at the firm. He wanted to avoid an potentially embarrassing situation about a client that was unhappy with the legal services that he provided and wanted $2.5 million in fees back. That's what seems to be at the root of his conduct. But to take that and go to a level of committing financial fraud doesn't make any sense at all. Why did Kevin Steele go to these lengths to commit this sophisticated financial fraud just to save face. It doesn't make a lot of sense that he would do that. It shows to me someone who's a real risk taker, who believes that they can pull off a scheme that involves a significant paper trail, one where forged financial documents are being provided to a bank, and then forged information is being provided to the law firm. Money is being taken out of law firm accounts and then provided to another person. All of those steps leave Kevin's fingerprints all over them. So to think that he was going to get away with this somehow was extremely naive. It tells me that Kevin wasn't really a very sophisticated criminal. This probably was something that he had not thought out extremely well, and appears to have been really the result of some extremely bad choices that he made, perhaps in a moment of panic, but it doesn't excuse the fact that he created all of these false instruments just to avoid telling his law firm about a very unhappy client.
Kevin Steele threw away a lucrative career, a sterling reputation, and his freedom due to pride. He risked and lost everything to avoid being exposed for committing legal malpractice. Steele chose deceit and fraud instead of honesty and humility, and will suffer the consequences of his decision for the rest of his life. Still to come on Charged and Disbarred.
Bradley Slogrove approached the court inappropriately. As a lawyer, you shouldn't be making any threats at all. He argued that he was being a good advocate, arguing for his client's case.
This is Charged and Disbarred. The Law Society of the Australian state of New South Wales can trace its origins back to 1842, when a small group of solicitors recognized the need to promote good feeling and fair and honorable practice among members of the profession, so as to best preserve the interests and retain the confidence of the public. Over the last 175 years, the Law Society's practices and protocols have been held to the highest levels of excellence. They've been tried, tested, and refined in the courts of New South Wales. The result is the emergence of a first world law society that holds the officers of the court to the highest of standards in legal practice. Anyone who disregards these standards and protocols is met with the severest of punishment.
I'm Marlene Eberger, a lawyer working in Werribee, Melbourne, Australia. I'm an accredited family law specialist. I've been a lawyer for just 11 years. Prior to that, I was a community development worker. I wanted to study law all my life, so I decided to go back and became a lawyer when I turned 40. About 13 years ago, I started working as a lecturer and was given the role to teach legal practice and ethics. And through that, I started to discover that there were some really bad lawyers out there. Lawyers who steal their clients' money, lawyers who lie to judges, lawyers who abuse other lawyers, lawyers who do the wrong thing by the profession. When you're admitted as a lawyer in Australia, first and foremost, you're admitted as an officer of the court. So it's a very serious matter to disrespect the court.
It is interesting to note that there are some unique differences between the legal practice protocols one can expect in America and those of Australia.
Each state and territory have their own regulatory body. So for example, in Victoria we have the Legal Services Commissioner and the Legal Services Board. And the board actually gives you the opportunity to practice. So you apply to that board for a practicing certificate to enable you to practice as a lawyer. They also regulate your behaviour. We have laws, acts of parliament, we have rules, we have regulations that tell us as lawyers how we are to behave.
In Australia, the legal profession has barristers and solicitors. A barrister's role is primarily advocacy, going to court on your behalf and filing pleadings. A solicitor gives counsel and guidance to clients.
Solicitors' rules, barristers' rules tell us how we must conduct ourselves in practice. What is the ethical behaviour expected of a legal practitioner? If there's a complaint made to them, the regulatory body is the one that will investigate that complaint and the one that can take action, legal action, against the lawyer that's done the wrong thing. So they'll take that action to a tribunal. Each state has their own tribunal or court where lawyers' complaints are dealt with. Disciplinary complaints for either misconduct or unsatisfactory conduct. Misconduct is the more serious matter, and sometimes you'll lose your practicing certificate. In America, you call that being disbarred. In Australia, we call it being struck off the roll. In court, we never say in this country, may I approach the bench? Unheard of. Absolutely unprofessional to even consider doing that. As a lawyer, and I've got a matter in court, I need to speak to the judge's associate. I can never approach the judge directly, but I might be able to write to the judge's associate. If I was to do that, I must include the other side in any communication. It's really inappropriate for a lawyer to contact a judicial officer.
Which brings us to the bizarre behavior of a lawyer named Bradley Slogrove. Slogrove is a graduate of the prestigious law school at the University of Sydney, Australia. He holds a Master of Law degree and was accepted to the Bar Association of New South Wales in May 1984. Mr. Slogrove enjoyed a long and successful legal career. He also gave lectures in international law at the University of Sydney. He was a respected member of the legal community.
There was a case in New South Wales about a barrister called Bradley Slogrove. He was one of these characters that decided he would approach the court inappropriately. In fact, what he did, as a barrister, he was instructed by a solicitor to act on behalf of a client. It was an interesting case. It was about an extradition case, about an Australian-Serbian gentleman. There was an extradition order for him to be taken back to Croatia for war crimes, allegedly. What Mr. Slogrove did, being briefed by the solicitor, he assisted the solicitor by drafting a document that was to be sent to the court. The letter went out with the solicitor's name. The letter was very disparaging of the magistrate hearing the case. In fact, it made threats to the magistrate. It asked for that magistrate to be recused, to not hear the matter, to be replaced by another magistrate. This is unacceptable behaviour of a legal practitioner in this country. The solicitor should have known better.
It was very bizarre behavior for a lawyer to act in this manner towards the court, let alone a lawyer who had been practicing law successfully and without incident for over 20 years. One can only guess why Slogrove would choose this course of action. Perhaps a closer look at the man Mr. Slogrove was defending at the time can provide some insight.
U sudnicu je doveden iz splitskog istražnog zatvora. U optužnici stoji da je mučio zarobljene hrvatske vojnike i policajce.
The Republic of Croatia accused Serbian suspect Dragan Veselikovic of committing war crimes during the Croatian War of Independence fought between 1991 and 1995.
A mislim da nema ni poštovanja prema sudu.
Interpol issued a warrant for Dragan Veselikovic's arrest in January 2006 in Australia. It is important to note that whether Bradley Slogrove thought Mr. Veselikovic was guilty of the war crimes or not is beside the point. He was representing his client in the matter of his arrest by the Australian government. Mr. Slogrove believed that the arrest and potential extradition were both unlawful.
Nikada do današnjeg dana nisam upoznao jednog Srbina koji je s puškom u ruci pravio moju Jugoslaviju.
He also believed that the magistrate presiding over the extradition held views prejudicial to his client. In light of all this, Mr. Slogrove submitted a letter to the local court registry. Amongst other complaints, Bradley Slogrove's letter contained the following. Our contact with the registry reveals that this matter is to be listed before Magistrate Moore on March 3, 2006. We advise there will be an immediate application in open court to disqualify Magistrate Moore should he sit. We expect that another magistrate will be provided by the registry. As you are aware, Magistrate Moore will not be able to make any direction or order in this matter, and we will be seeking no order or direction from Magistrate Moore. We refer you to the transcript, January 27, 2006, at page 11.40, where Magistrate Moore makes a prejudicial observation that the New South Wales Crime Act may be applicable to alleged offenses against prisoners of war should such alleged offenses occur within New South Wales. He has already prejudiced an extradition objection that our client will be making in these unconstitutional and illegal proceedings which we protest. This is a textbook example of completely unacceptable conduct in terms of protocol and procedure by a lawyer when engaging with a judge or magistrate through the local court registry.
The rules clearly say we cannot approach judges, magistrates. Clearly we have to conduct ourselves in a professional manner.
So not only did Bradley Slogrove approach the court in an inappropriate manner, the tone of the letter was threatening and bombastic.
We all have to be fit and proper people to be able to hold our practicing certificate. The court were able to determine that in fact the letter was not drafted by the solicitor, but it was in fact settled by the barrister. And action was taken by the regulatory body in New South Wales to strike off Mr. Slogrove's name from the Supreme Court roll of New South Wales.
The natural consequences to Bradley Slogrove's behavior was that he was to face disciplinary action from the Law Society. The official charges brought against him were professional misconduct, intimidation of magistrate, and breach of barrister's rules. Slogrove was issued a citation from the Administrative Decisions Tribunal of New South Wales. In considering their findings and deciding on an appropriate penalty for his conduct, the Administrative Decisions Tribunal of New South Wales additionally took Mr. Slogrove's inconsistent approach in his dealings with the tribunal into consideration. Bradley Slogrove initially denied sending the offending letter to the court. He sent a letter to then Bar Association President Mr. Slattery QC stating, "I fundamentally deny writing any letter on March 2nd, 2006, or at any time threatening to independently sue Magistrate Moore in false imprisonment or exemplary damages if he did not disqualify himself on March 3rd, 2006. Slogrove later took a more aggressive and unapologetic position while still not admitting that he was the author of the letter, stating, "I do not, unlike my instructing solicitor, apologize for the letter of March 2nd, 2006 and stand by its contents. His apology is not binding on me. Magistrate Moore was railroading Mr. Vasilikovic and had to be confronted." He finally admitted to drafting the letter of March 2nd, 2006, but the tribunal representatives noted that Mr. Slogrove showed no sign of contrition. Their decision was reached. Mr. Bradley Slogrove was struck off the Bar Association of New South Wales.
It's a really big deal for lawyers to approach judges and to make threats. As a lawyer, you shouldn't be making any threats at all. In Mr. Slogrove's case, he argued that he was being a good advocate, arguing for his client's case. You just can't do that here.
Having a law career can be incredibly rewarding, but it is not without its challenges. One of the toughest scenarios that lawyers face is when they become emotionally overinvested in their client's case. When that happens, it becomes almost impossible to serve your client's best interest.
I had to work really hard to become a lawyer. I had to work really hard to build my practice. When I see that there are lawyers out there who are going against what I was trained to do, it makes me feel quite ashamed.
It seems, unfortunately for Mr. Slogrove, that he had fallen into this trap.
It's really interesting to note that after Mr. Slogrove was disbarred, he continued to champion the case of his client. In fact, I read recently that he was in the Netherlands trying to argue this case and have it heard in The Hague, in the International Criminal Courts.
As a result of Mr. Slogrove's actions, things did not turn out so well for his ex-client.
The newspapers report that the person wanted for the extradition was found because a phone call was intercepted between the previous client, or the wanted, and Mr. Slogrove while he was in the Netherlands.
In the end, one can only guess why Mr. Slogrove would put a stellar 26-year career on the line for a single client. Even more of a mystery is why Mr. Slogrove kept pursuing his ex-client's cause even after his involvement cost him his career.
Mislim da nemaju ni poštovanja prema sudu, da takve bezlične laži koje su očigledne I površničke.
Samo moram vas prekinuti, ne smijete ih samo vrijeđati.
Prior to reading about this case of Mr. Slogrove, I actually had never heard about him. So I'm not sure whether there were other disciplinary proceedings. Not sure, maybe other members of the New South Wales Bar weren't happy with the way that he approached the court system there, because it can't just be one charge. It can't just be one charge for somebody to be struck off. There has to be a bit more to it, but I'm not quite sure what that is.